Welcome to the Founders Constitution, a podcast style of lectures about the Constitution's parentage, birth, early childhood, and, shall we say, rowdy teenage years. We'll share some stories about the principles, practices, and people who gave the Founders Constitution form and substance. I'm Robert Baker.
It's other people who do not know what their past is.
Viewed against history's backdrop.
Don't know what their present is.
Basically, history has proven.
And the people of whom this is true
We are the masters of our fate.
probably have no future.
Welcome to the Founders Constitution. Episode 4, The African and the Chief Justice. In 1749, a Scottish merchant by the name of Charles Stuart made a purchase. He made a lot of purchases. That was his living. He traveled the British colonies, purchasing goods in one port and selling them in another, from Jamaica to Charleston to New York, and so on. He was a peddler. But his purchase in 1749 was different. He purchased a boy, a precocious boy, an African boy named James Somerset. It was a big purchase for Charles Stuart, but even he wasn't aware of how big it was, because James Somerset was going to shake the foundations of British slavery. Part 1. James Somerset, the Man. James Somerset was born in Western Africa. He was born free and had been kidnapped by African slave traders as a boy. Thereafter, he was destined for the coastal slave markets, where he was weighed, measured, and then sold to European slave traders. Millions suffered Somerset's fate. The vast majority of the more than 10 million men and women, mainly men, who fell victim to the slave trade were destined for sugar islands, tobacco farms, or rice swamps of the Caribbean and southern climes of North America. Their bodies were stolen and their labor appropriated in a massive system of plantation production that brought valuable staple crops to the European consumer markets. North America was a latecomer to the Atlantic slave trade. Africans did not arrive in large numbers until the 18th century. Eventually, 500,000 Africans would be brought into North America. There they joined free men and free women, as well as indentured servants who were themselves unfree laborers. Enslaved people worked in ports like New York and in the Hudson River Valley and in the rich agricultural valleys of Pennsylvania. Enslaved people lived in all of the North American colonies, although in far greater numbers and proportion in the populations that resided south of the line which in 1767 was being surveyed by Charles Mason and Jeremiah Dixon to fix the border between Pennsylvania and Maryland. This was the world into which James Somerset had been thrust. In a way, he was lucky. Millions of African boys had been delivered to the Caribbean, where life expectancy for a captive might be 5 years or 10 years, all of it being spent in grueling labor under appalling conditions. Somerset was precocious and young. It was a servant's life for him. And there is some evidence that Charles Stuart prized his newest acquisition. Somerset helped him keep books. Charles Stuart gave Somerset expensive gifts. Several merchants who traded with Charles Stuart remarked on Somerset's extraordinary qualities. In 1769, Charles Stuart made a business trip to London, and there he resided for some time, negotiating bigger and bigger deals than he ever had before. Charles Stuart was an ambitious peddler. He had goals. For 2 years he had worked with the London merchants. James Somerset, meanwhile, became acquainted with London's black population. The West Indies planters had brought enslaved Africans to London, but free Africans also resided there. And so, in 1771, James Somerset decided he would depart Charles Stuart's service. He walked away. Or maybe he ran. Maybe he didn't come home one day. We don't know. We do know that Charles Stuart was not happy about this. He immediately hired 2 men to find James Somerset. And they did. Stuart ordered the men to seize James Somerset. And they did. Stuart had the men place Somerset in irons and put him on board the ship, the Anne and Mary. It was hard to imagine, but Stuart was within his rights under the common law. There was something called the right of recaption. That's recaption, recaption. It meant the right to recapture somebody who had fled your household, somebody who was bound to you. The right of recaption was a right that the husband had over a wife, a right that the father had over a child, and a right that a master had over a servant. The common law gave the patriarch power to pursue those who fled his household, to take control of them, and to bring them back. Charles Stuart then made arrangements with his friends amongst the West Indies planters. He would take Somerset to Jamaica and there sell him on the open slave market. James Somerset would spend the rest of his days, most likely, on a sugar plantation. But James Somerset had other ideas. Part 2. Allies in the Struggle. Somerset got word to his friends in the free black community of London. Some of them had begun to take a principled political position against slavery. It was a young movement, not very strong, but it had attracted some talented Africans, notably Olaude Equiano, and it had gained some influential British allies. One of them was Granville Sharp. Granville Sharp was the 9th son of an aristocratic family that was clearly in decline. If you need proof of this, consider that Granville's lucky birth into a wealthy family landed him a job as a draper's apprentice in London. But Sharp was curious and bright and kind of weird. He worked alongside a Jewish apprentice who told the Protestant Granville Sharp that he could not really understand his Bible because he was reading it in English translation rather than the original. So, Sharp taught himself how to read Hebrew and Greek. Granville Sharp's first shocking encounter with slavery came in 1765, some 4 years before James Somerset would arrive in London. He was walking on the street when he came across a man named Jonathan Strong. Strong was lying on a bench, half dead. He had been enslaved by a Barbados planter named David Lyle. Lyle had brought Jonathan Strong with him from Barbados to keep as a servant. David Lyle was a bully and a brute. He became angry with his slave and then pistol-whipped him so badly as to nearly blind him. And so, David Lyle turned Jonathan Strong out into the street and left him there to die. Granville Sharp took Strong to his brother, who was a physician. Strong needed 4 months to recover from his injuries, but he did recover. Sharp then helped Strong find work as a messenger. 2 years later, David Lyle spotted Jonathan Strong on the street. Maybe Lyle was surprised that Strong was still alive. Maybe not. Either way, he ordered Jonathan Strong seized. Strong, Lyle figured, was his property, and he had the common law right of recaption. Granville Sharp intervened. His family might be in decline, but they still knew people. Sharp convinced the Lord Mayor of London to release Strong from Lyle's custody. Lyle was furious. He challenged Sharp to a duel. Sharp refused. Lyle sued Sharp for the loss of his property. That was not a challenge that Sharp could refuse. Remember how Sharp had taught himself Hebrew and Greek so that he could have a proper conversation with his fellow apprentice, the Jewish man at the draper's? Well, in order to defend himself in court, Granville Sharp researched and wrote an entire treatise on slavery and law. He published it in 1769. It was titled A Representation of the Injustice and Dangerous Tendency of Tolerating Slavery, or of Admitting the Least Claim of Private Property in the Persons of Men in England. Sharp's treatise began with the fact that the common law did not recognize slavery. This was true. Roman law recognized slavery, and Roman law was the basis of every other major European power. But the common law, English law, did not. Granville Sharp could quote the words of a 16th century judge who said that the air of England was too pure an air for slaves to breathe in as evidence. He could trace English freedom all the way back to Magna Carta of 1215. Sharp then argued that judges should refuse to admit the law of slavery for two reasons. First, Sharp could point to a string of judicial decisions that had refused to admit the law of chattel slavery. This meant that the courts should follow those decisions. This is the principle of stare decisis. Second, to change the law and admit the innovation of slavery, argued Granville Sharp, would do great mischief. It would invite oppression. It was dangerous. In short, Sharp's argument against slavery was not a progressive one. It was deeply conservative. But it was also deeply unsettling to the British West Indies planters. The West Indies planters were wealthy and powerful, and their wealth came on the backs of slave labor. They regularly bought and traded human beings through the ports of Liverpool and London, and their immense fortunes depended upon a mass of legal and clerical work in accounting and insurance and merchandising that was conducted almost exclusively in London. Sharp's treatise essentially called the whole enterprise illegal. Granville Sharp had been awoken to anti-slavery. He was a powerful ally for the people who sought their freedom. He had money and connections, and he had legal arguments. The first order of business in James Somerset's case was filing the right writ. In the common law, a complicated number of writs determined the type of action one was bringing. In this case, Somerset's lawyers filed for a writ of habeas corpus. Habeas corpus was the writ you filed when you were unjustly detained. But that word unjustly is a little misleading. By unjust, the writ asks, is the detention according to the right form of law? So the writ tests not the reason for detention, but rather the form of the detention. Take this simple example. Let's say that a man is framed for murder. The prosecutor doesn't know that the person was framed, and the evidence is strong. He asks a court for an arrest warrant, and the court issues an arrest warrant. The man is arrested and taken to jail. The man sues out a writ of habeas corpus. The writ of habeas corpus commands the jailer to bring the prisoner before the judge who issued that writ and explain why he is detained. The jailer complies, bringing forward the prisoner. The judge in that case would not ask, is this person guilty of murder? But, was he jailed according to correct legal process? The answer in that case would be yes. The suspect was jailed on an arrest warrant and therefore by proper legal process. Even if the judge knows that the suspect is not guilty of murder, this is not the question that judge is being asked. That is for another court to decide. This is what the Court of King's Bench in 1772 confronted when it issued a writ of habeas corpus in the case of James Somerset and Charles Stuart. The writ commanded Somerset's detainers to state by what authority they held him. The answer came back on the writ from the captain of the Anne and Mary. I hold James Somerset because he is the legal property of Charles Stuart, and Stuart wants me to hold him here until we sail out of the realm.
Part 3. The Judicial Opinion Heard Around the World.
The Chief Justice of King's Bench was Lord Mansfield. He was born William Murray in 1705 in Scotland. His family had had strong sympathies for the Jacobites. Those were the people who had refused to accept the constitutional settlement of the Glorious Revolution and continued to maintain that James II was the lawful king and that his son James should have succeeded him. It wasn't the most auspicious start to a career to have Jacobites in the family, and William's parents shipped him off to England for education, where no one knew of his family's political leanings. He would go on to be educated at Christ Church, Oxford, and then to London, where he was called to the bar and became a barrister. He would go on to a celebrated career. In 1756, William Murray was appointed Chief Justice of King's Bench, and with it, King George bestowed upon him a noble title, Baron Mansfield. In 1776, he would become the first Earl of Mansfield. On King's Bench, Lord Mansfield quickly became the most influential jurist of his age. His decisions on commercial law virtually established the modern field. In 1772, Lord Mansfield now had James Somerset's petition for a writ of habeas corpus before him. He had but one thing to consider. Was the detention according to law? Several lawyers appeared for both sides, and it became clear quite quickly that both sides wanted to use this as a test case. Somerset's lawyers wanted the Chief Justice to rule that slavery was against the common law and thus void. The West Indies planters wanted Lord Chief Justice Mansfield to hold that slavery was legal in England and that their property would be secure. Somerset's lawyers argued that slavery could not exist by English law. To prove this, they drew a line of precedents. They began with Magna Carta's famous Chapter 39, which declared that no freeman could be imprisoned except by the law of the land. They then pointed out that the Parliament of Edward III in 1346 had extended Magna Carta's provisions to everyone. Finally, the 1679 Habeas Corpus Act guaranteed that any person could sue out the writ of habeas corpus. If all these things were true, they reasoned, then slavery was not logically consistent with the ancient, venerable common law. James Somerset was entitled to the writ of habeas corpus, and he was entitled to his freedom. Charles Stuart had been provided lawyers by the West Indies planters. They laughed at the proposition that slavery was against the common law. They raised three main points. First, Parliament had passed statutes that authorized merchants to conduct the slave trade, and Parliament's law was supreme. Now, Parliament had not recognized slavery in England proper, but they had certainly implied it. Slavery was tolerated all throughout the empire. Second, English courts had recognized slavery as existing in the colonies, and they had enforced slave contracts in England. Granted, judges had been forced to strain logic or to insist on specific kinds of pleading in order to maintain the fiction that slaves did not exist in England. But here the West Indies lawyers poked a significant hole in Granville Sharp and all of the lawyers for James Somerset's legal theory. English judges had never held specifically that slavery could not exist in England. Statements like, "The air of England is too pure for a slave to breathe in," were colorful, but they were dicta, not enforceable law. Third, the West Indies planters had in their possession a legal opinion authored by two of England's top legal minds, Attorney General Philip York and Solicitor General Charles Talbot. The York-Talbot opinion had been solicited in 1729 by West Indies planters who were nervous, even at that early date, that their property interest in human beings was insecure if they brought enslaved people to England. The York-Talbot opinion, it was just a legal opinion, but its authors were greatly respected. The York-Talbot opinion carried weight. It asserted that 1. Enslaved persons did not become free by traveling to England. 2. Baptism did not free enslaved persons. And 3. An enslaver had the right to compel an enslaved person to leave England. The trial itself was becoming a cause célèbre. Arguments bordered on the theatrical. The papers had taken note. Lord Chief Justice Mansfield became nervous. This was the kind of case with larger implications than the freedom of one man. He urged the two sides to come to agreement. And there seemed to be a way out. Friends of James Somerset had raised money to purchase his freedom. That would settle the case. Somerset would be free, Stuart would get his money. Everybody would leave happy. But Charles Stuart said no. The West Indies planters who paid for his lawyers told him they wanted a decision. This was their test case. "Very well," said Lord Mansfield. "You want a decision? You will get a decision." He surveyed the courtroom. The lawyers, James Somerset, Charles Stuart, Granville Sharp, the West Indies planters, the spectators interested in this interesting case. And then from the bench, in a voice that had become famous, not just before the bench, but in Parliament and in speeches, he thundered,
Fiat iustitia ruat caelum.
Translation, "Let justice be done, though the heavens may fall." On Monday, June 22nd, 1772, Lord Chief Justice Mansfield and and the other judges of King's Bench entered the court and took their seats. Mansfield announced that he had reached a decision. After reciting the facts of the case, Mansfield got to the heart of the matter. The seizing and detaining of Somerset for the purpose of transporting him out of the realm was an act of high dominion and could be tolerated only if allowed by positive law, that is, a statute passed by the legislature. He explained further that slavery was of such a nature that it derived its existence from no other source of authority than legislative enactment. Neither custom nor foreign law would suffice. Slavery was too odious to be suffered except by positive law. Therefore, said Mansfield, Somerset was not detained according to a valid form of law. The prisoner must be discharged. James Somerset was free. Mansfield did not issue a written opinion. None of the judges did. They decided the case and spoke directly from the bench. Some reporters sat in the court and they recorded what Mansfield said for their law reports. The lawyers who read the case would immediately have had to argue about whether the decision was a narrow one or a broad one. This was what lawyers did, what they had been doing for centuries. But this was a debate that engaged more than just lawyers. People awakening to the anti-slavery cause read the opinion eagerly, and they gave it their own gloss. So too did slaveholders, although they read it with trepidation. Somerset v. Stuart was widely reported in the British colonies in 1773. The timing could not have been more perfect. North American colonists had been arguing for their liberty over British slavery for nearly a decade, although their argument was about taxation, not about actual liberty. But Mansfield's ruling resonated in the colonies. Its resonance coincided with swelling anti-slavery sentiment. The first public petition to legislatures by Black people appeared in Massachusetts in 1773. In 1774, a mass petition demanding freedom cited the principle that the common law did not recognize slavery. The first organized anti-slavery society formed a year later in Philadelphia in 1775, although the arrival of war a year later would arrest its first actions. Soon, a transatlantic, multiracial movement against slavery would begin. But if we need any real proof of the effect of Somerset in the colonies, we can find it in Virginia in 1773. A man and his wife, both enslaved, had stowed away on a ship. They were discovered, arrested, and returned to their enslaver. They were asked, "Where did you think you were going?" "England," they replied. "Why?" they were asked. "Because," they replied, "everyone is free in England." That's our story. If this were a real podcast, I'd tell you to go to Stitcher or Spotify or wherever you get your podcasts and rate us. In this case, please take some time to fill out the anonymous survey. I've provided a link on the class website. Music is by Katie Gunn, an independent artist living in Brooklyn, New York. You'll find a link to her music on the website. If you have any questions or comments that you would like to share, please make sure to visit the discussion threads. See you next time.